All right, we are on the record. We are outside the presence of the jury. Mr. Bahena is present along with the attorneys of record. And at this time, we are going to make record regarding the instructions and verdict form. Let me start with the state. We have provided to you 33 proposed instructions and 1 verdict form. Mr. Brown,
Judge,
what record do you wish to make?
We've had a chance to review the instructions. All of them appear to be from the stock set of instructions that we utilize. I just wanted to verify with the court that there were no deviations from stock instructions.
To slightly quibble, and again, I think this is a small one, but I don't believe 30, the smoking instruction, is, but I think you've probably seen it enough, and maybe it's become standard. But I know of no deviation.
I actually haven't had the smoking instruction given for some time, but I have no problem with it.
Okay.
So given that, Judge, based upon our review of the instructions, they appear to be complete, and the state accepts the instructions as provided by the court.
And no objections.
And no objections, correct.
All right, we'll turn to the defense. Again, you've also been provided the 33 proposed instructions in the verdict form. What record do you wish to make?
We do object to instruction number 9. We would propose instruction, and that's dealing with the reasonable doubt instruction. We would propose the 100.10, the reasonable doubt instruction that has been submitted, I think, within the last couple of years and is in the criminal proposed instructions updated through June of 2020. We believe that the hesitate to act portion that is laid out in 100.10 is appropriate. We think that it adequately expresses the law. I'd also note that a similar instruction has been approved by the 8th Circuit Court of Appeals, so we would submit that instruction should be used instead of what I would quote as the old reasonable doubt instruction.
All right, we'll come back to you in a minute. Just as it relates to number 9, what's the state's position?
Judge, I think the instruction that you are giving is, I think, one that we proposed. It is the older stock instruction, but State versus Fry, F-R-E-I, which is an unpublished opinion. I don't have the exact citation off the top of my head, but has indicated that this particular instruction has been approved by our appellate courts. I think it correctly states the law. I think it's much simpler than the instruction that is in the current set of stock instructions. And so we would ask that you give the instruction number 9 as proposed. I know I worked recently, within the last couple of years, with Judge Gookin in the 8th District on a case down in Centerville who provided the same instruction. I've had other trial judges give it as well. So I think it's a correct statement of the law. We'd ask that it remain.
Ms. Fries, you've made your record for all of the reasons stated by Mr. Brown. We will stick with number 9 as is. Any other record you wish to make?
Yes, we would also propose the expert witness instruction. That is 200.37.
All right.
We would also propose the character and reputation instruction. That's 200.38. And we would propose the dangerous weapon instruction. That's 200.21. We would submit that those instructions all pertain directly to issues in this case, and that they are issues that have been brought up and that they adequately address the law.
Dangerous weapon, was that 200.21?
Yes.
All right. Take those in order. Expert witness 200.37. Mr. Brown, what's your thought on that?
We have no objection to to that instruction.
Okay, and I think it would seem to apply equally to both sides, so we will get 200.37 added. And again, just for the record, obviously there will be another instruction added, so we won't end at 33. So expert witness is fine, coming in by agreement, and again, it appears to make sense for both sides. Mr. Brown, on the 200.38, the character instruction.
Give me just 1 second, Judge. I believe there have been at least a couple witnesses who have testified concerning character and reputation of the defendant, so I think that's appropriate.
By agreement, 200.38 will also be added. And then 200.21 being proposed. Dangerous weapon, is that what you said?
Yes.
Okay. Would you take a look at that, Mr. Brown, and give me your thought on that?
I thought that was already in your instructions, is it not?
I didn't see it, but
Hang on. We don't have any objection. It's a definitional instruction regarding dangerous weapon. We're into the elements. Part of that is that Mollie Tibbetts was stabbed. I think that's the evidence in this case, that she was stabbed to death. Obviously, that was done by a weapon that could do that. So 200.21 is acceptable.
200.21 will be added, and again, I'm not saying you're done yet, but so we would be up to 36 instructions. Ms. Freeze, anything else?
no.
Okay, so we will work those three in, and I don't think that will take us very long, given all three are stock instructions. So to the extent you would like those, we could give those to you before you leave here today. From the state standpoint, anything else on the record?
No, is your intention to read instructions first all the way through the verdict form?
So what I was going to do is go off the record. We'll go back to chambers and try to get a handle on tomorrow, so we can address that in chambers, okay?
Nothing else.
Defense have anything else for the record?
No.
Okay, we'll close the record for today. Thank you, everyone.